But don't ever let somebody tell you that it's not worth just your vote to secure a better position in the Supreme Court. Because we are seeing right now the results of Trump's 4-year run and 4-year ability to nominate judges.
Imagine you're a newly unionized Starbucks barista discussing whether to strike. You've got lots to think about, but what you probably wouldn't expect to have to consider is whether your union-busting boss, Howard Schultz, is going to sue you for the impact of your strike on Starbucks, for the coffee that gets wasted or milk that goes sour or lost revenue from customers who get tired of waiting in line.
Which is fucking ridiculous.
If the Seattle Concrete Mixing Company and the U.S. Chamber of Commerce get their way before the Supreme Court this year, that's the crazy position that American unions are going to be in if they want to strike. And it could be devastating for workers everywhere. The case the Supreme Court is considering...
Dude, this fucking murderer's row, man. The idea, I'll never stop saying it, fucking expand the court, make it fucking useless for the rest of time. Unless we're on top. That's how Democrats need to be doing this. They need, I have probably said this in every single segment I've ever done on the Supreme Court. What Biden should have done day one, expand the court, fill it with liberals, tell Republicans, if you expand it, when I'm gone, you expand it, the policy of the Democratic Party is to keep doing this until you all cease, until there is a stop of this hyper partisanship in the court. Like, quite frankly, threaten to blow it up. Either like the Supreme Court only lives on the idea that it's a neutral arbiter, which it obviously isn't. But there's no reason why Democrats should continue to put up with this bullshit. Supreme Court with that's been stacked with fucking conservatives through like bullshit means. Like, fuck it, fuck the rules, fuck the niceties, just get in there and commit politics. Anyway,
is called Glacier Northwest versus International Brotherhood of Teamsters Local Union 174.
Fuck, dude.
And here are the facts. After months of contract negotiations, cement mixers at Glacier Northwest decided to go on strike. They drove their trucks back to the company's headquarters and walked off the job. Workers left trucks that had already been loaded with cement running so that the cement wouldn't instantly harden inside the truck's drums.
Makes sense.
The strike lasted 1 week before the companies reached agreement on a new contract. The issue in this case revolves around what happened next. The employer sued the Teamsters for tortious destruction of the company's property. Glacier asked a Washington state court to make the Teamsters pay for damage to their trucks as a result of cement hardening after the strike began. The Washington State Supreme Court threw out the case, finding that it wasn't appropriate to apply state law to a labor dispute covered by a federal law, the National Labor Relations Act.
Makes sense.
The state Supreme Court...
The NLRA protects workplace democracy by providing employees at private sector workplaces the fundamental right to seek better working conditions and designation of representation without fear of retaliation. Makes sense?
This decision rested on long-standing U.S. Supreme Court precedent that the National Labor Relations Board decides whether union conduct is protected by federal law or not.
Makes sense.
This should have been the end of the story. Unfortunately, it wasn't. As we've seen with the supercharged...
Dude, fucking disgusting.
Conservative majority currently sitting on the Supreme Court, no precedent is safe. To date, the Supreme Court has recognized the importance of the right to strike and allowed state law to sanction strike activity only when a union's behavior is so egregious that striking workers have lost the protection of the federal law. Think violence on the picket line or obvious vandalism at the employer's place of business.
Makes sense.
But in this case, there are no allegations of violence, and the drivers even tried to mitigate harm to the trucks by leaving them running. Bottom line, it shouldn't be the union's job to make it as easy as possible for an employer to weather a strike. The whole...
Wait. Okay, yeah, and that's complete bullshit. Because at the end of the day, if your workers walk the fuck out, like if I'm in a kitchen and we decide to go on strike And because there's no workers, because there's nobody to organize the fridge, there's nobody to make any of the food, and you're like, oh, damn, this food's going to waste because I don't have workers. Guess what? Fuck you. That's on you. What that is actually is a tool that workers have because, you know, like a lot of jobs, right? So the idea of like the worker's value, right? You take a loaf of bread, you take some ham, you take some mayonnaise, right? If you don't have a worker there to cut the bread, to slice the bread, to spread the mayonnaise, to distribute the ham, then dumb fuck, you know, maybe you should have treated your workers better, or you just bought a bunch of food to go to fucking waste. And it's one of the ways that like workers can actually use the value that they put into the resources. An owner, the company, whoever buys each of those individual resources at a, you know, usually at like a bulk price that's lower than what they're going to be offering once you bring all of them together into, let's say, a sandwich. But to get to that sandwich, to get to the thing that is worthy of more value, you need a worker to input their labor to then get you the sandwich that you can sell for $13 or whatever the fuck, right? And at the end of the day, if you're a business that is not treating their workers well, if you're a business who's not doing the thing, who's not, upholding the relationship between worker and employee and employer, then guess what? You bear the cost of buying all the resources and wasting all the resources. That's the cost that you pay. The cost for the worker is to not get paid. Their cost is now I don't have a job right now. I'm not making any money. That's the cost that the employee pays. The employer pays the cost of, oh, your resources, if they can, will go bad. Or, you know, you'll get backed up on orders or whatever it might be. But that's always been the cost, and that's always the trade, and that's always the negotiating, the bargaining tool. It's like, all right, you guys need to get paid eventually. We need to have our resources distributed and your labor inputted into them to create valuable products. But you know, now that the Supreme Court has decided, oh no, the onus is now on the employees for the resources bought by some private organization, some private corporation. Guess what, buddy? As every single business owner has ever told you, you took a risk, Bubbo. Why did I say Bubbo? You took a risk, buddy. And now you pay for that risk. Fuck you. Those are your resources. You fucking pay for them. But we have a Supreme Court right now that's not exactly incredibly pro-labor, mainly because they all come from, the Federalist Society, who's funded by corporate sponsors. Funny that, right?
Point of a strike is to create an economic incentive for an employer to bargain seriously with the union. But even if this was a close case on the facts, which it isn't, the Supreme Court still had no business hearing it. It's the job of the NLRB to decide if strike behavior is egregious or not. So why is the Supreme Court getting involved to open the door for companies to sue unions that strike? Because this court has shown a sustained hostility to workers' collective bargaining rights. Just a few years ago, it reversed decades of precedent to make it harder for public sector unions to collect dues. And 2 years ago...
And keep in mind, they're against workers collectively bargaining. But do you think they give a shit about your Walmart down the street, your Best Buy down the street, your Target down the street, all of these big box stores? Do they have any issue with all of them coming to a, silent agreement that they're all going to pay the same basic wages, offer all the same basic benefits, meaning that workers have less and less choice between between the actual companies, that working for Best Buy and working for Target, not all that different. Not going to be making a whole lot more. Maybe you make like a little bit more at one or the other, but as with a lot of things, a lot of these companies price match with each other, which means they're also matching when it comes to labor. Because again, if you're a big box store and you're splitting the market share in any area in a way that's beneficial for everybody, you don't need to compete anymore. Now you all just run all of the small businesses out of town, and now you've got like 4 options, all taking up 25% each of the market share, all going to do well until infinitum. So, I mean, but does the Supreme Court have anything to say about that? Are they interested in any of those kinds of, relationships? Those, they're unspoken and whatnot. But if you don't think that some of these companies are trading executives every once in a while, you'd be crazy. But, it's not something the Supreme Court's interested in.
It made it impossible for union organizers to talk to farm workers in the fields of California. And now conservatives are plotting to make it easier for wealthy corporate bosses to be able to sue union employees just for asserting their constitutional right to strike. At a time of historic levels of worker organizing,
when these conservatives on the court talk about free speech,
exactly
keep
the
that
wrong
in mind.
time
You're not allowed
for the Supreme Court
to talk
make
to
the
farmers.
right to strike harder than ever for workers to exercise. But for the Roberts Court, it seems to always be time to side with corporate employers' efforts to undermine workers' rights.
God, fucking disgusting. Let's take a read. All right, I already read about this. An 8-1 ruling on Thursday, authored by conservative justice Amy Coney Barrett, made it easier for companies to sue over strikes that cause certain instances of property damage. The case involved a strike by the union representing truck drivers at the concrete. We know that. Angela Cornell Law School labor professor, called it another decision that undermines the capacity of unions to function. Wait, was that the same person? I don't think it was. Was it?
Imagine.
I don't think it is. Is it?
You're a newly unionized Starbucks
Did it say their name?
Discussing lots to think. Probably wouldn't expect to have.
No, this is a completely different person. Okay, cool. Just making sure. That would be really funny if they use the same source. Weakening the right to strike by making it riskier to exercise means it will reduce the only leverage unions have when negotiating with companies. This, of course, is a big tilt toward business interests and against the collective interests of workers. And keep in mind also, this is essentially like, this is the tool that you use to strike. You threaten the company's bottom line. And what the conservatives on the Supreme Court have decided is that you're not allowed in specific ways, or I guess it really is unspecific ways, to cost the company money, cost the company value, whatever. You're just not allowed to cost them, the company, anything that we think is out of line. Which, granted, I don't even still know if the NLRB is still in charge of this, or if it's like a that's kind of an overhead sort of thing. But like, that's the whole reason to strike, is you cost them their bottom line until they come to an agreement with you. You hold the company and the labor hostage. It is your labor. You have a right to hold it hostage. No company has a right to your labor. They have, and they have to live with the consequences if you refuse that labor. It's fucking stupid. Let's see. The decision is part of a systemic project by the Supreme Court to limit employee collective rights in the name of the industrial peace, while expanding employer weapons of lockouts and permanent replacements in the name of private property rights and free enterprise. Fucking absurd. Added Indiana University School of Law, Labor, and Employment Law professor Kenneth Dow Schmidt, who also joined a brief backing the union. Decision. 1 second. Expanding employers' rights. Yeah, of course. Yeah. Let's see. But according to Harvard law professor and labor and industry Sachs, if lower courts faithfully apply the reasoning detailed in Barrett's decision, then it won't do much damage to the right to strike. The court issued a very narrow holding that appears to be limited to a specific facts of the case involving the specific nature of concrete mixing. The court ruled in favor of Glacier Northwest, which sued a local affiliate of the International Brotherhood of Teamsters after a work stoppage forced the company. Yeah, we already know that. So keep in mind that, like, This dude is making the argument that's like, well, look, it's not going to do all that much because it's very controlled to this specific case. But here's the thing. It doesn't have to. Like a lot of law in this country and a lot of like the way in which how you structure and write laws, it's not just about the enforcement of that specific law. Go read any like law textbook. It's fucking incomprehensible. And for most normal people, it's incomprehensible. And the point is to make it so and to kind of gum up the understanding of what is and what isn't a legal strike in this case. So the idea is not like, oh, well, this won't actually, this only applies to this one thing, right? But if you're like, if you're in a Teamsters union in, Wisconsin, right? If you're in a Teamsters union in Wisconsin, you see this one happening in, where was this again? I don't remember what state. In Washington. You see this strike in Washington make its way all the way up to the Supreme Court and get denied. Meaning that there is a chance that if your company wants to go far enough, they'll push it to the Supreme Court. And the Supreme Court is willing to take it. And they're willing to side with the company. At the end of the day, it's going to create a chilling effect. It is there to disincentivize people from striking, not necessarily to break up strikes. It's just supposed to preemptively get in the way of strikes even beginning to happen, like halting the conversation early, making people nervous about it early. Let's see. The ruling comes at a time of increasing strikes called by U.S. labor unions. According to the U.S. Bureau of Labor Statistics, the number of American workers who participated in strikes and similar activities in 2022 increased by nearly 50% compared to the previous year. Cornell said the decision, quote, could chill the recent uptick in collective action by workers by placing unions at a greater risk of facing lawsuits if they go on strike. Dan Altschik, an attorney at the Philadelphia-based firm Saul Ewing, who represents employers in labor matters, said the ruling gives employers, quote, a bit of a roadmap for how to reduce the odds of a lawsuit over strike-related property damage from being dismissed. If and when such lawsuits survive a union's motion to dismiss, the litigation risk for the union resulting from the strike is significantly enhanced. Some experts pointed out that the ruling, also keep in mind, if you ever played if you're a gamer, you play video games, this is no difference than when in your favorite video game they fucking do a balance check and they end up like nerfing a core ability of a character and end up fucking buffing the core ability of another that didn't need it. It's literally all this is. This is labor unions. Labor unions get a buff. Business gets a nerf. Businesses get a buff. That's all this is. The court's analysis may have modestly lowered the union protection threshold in considering applicability or scope of the take reasonable precautions test, said James Brudney. Jesus Christ, a Fordham University Law School professor. Why do they have to include all this? Brudney called the aspect of the ruling a, quote, relatively minor development compared to the court's broader decision to leave intact its major framework for analyzing labor disputes of this nature. The Supreme Court, with its 6-3 conservative majority, has dealt setbacks to organized labor in key cases in recent years. In 2021, it struck down the California agricultural regulations aimed at helping unions organize workers. Oh yeah, this is the one she mentioned earlier. Don't ever let anybody, and this is also why I said what I said about Cornel West and about delivering his voters to Biden. Don't ever, ever, ever let somebody tell you that the Supreme Court and the ability to nominate judges to that point, or to appoint them, I guess, to that court, don't ever let them make you think that that's not a worthwhile, well, I know it doesn't feel, it doesn't have that feeling of like, whoa, of strong significance, or of like that, like exciting, like, whoa, yeah, we got a Supreme Court justice, woo. Like, I know it doesn't feel all that, significant, but don't ever let somebody tell you that it's not worth just your vote to secure a better position in the Supreme Court. Because we are seeing right now the results of Trump's 4-year run and for your ability to nominate judges. It's this sort of stuff matters. And just because you're sick of electoralism, and I get it to a degree, this stuff still matters a lot. The thing that they tell, like at the end of all YouTube videos where they tell you to like click on one of these like things to watch more videos. Yeah, I've been meaning to film one of those. So that's what I was doing. I was just setting it up to film one.